Hello, everyone. Welcome. We're just getting started. You are here for the panel on strategic litigation. My name is Mary Boak, and I am the Assistant Dean for Clinical and Experiential Education and Pro Bono programs at the law school. As we get started, you'll see on the screen that we have a little bit of a participation question. As I'm giving my introduction, you are welcome to answer the question, what do you associate with strategic litigation, or what is sometimes called impact litigation? During this panel, our panelists are going to be exploring with you all how they define and understand the meaning of strategic litigation. So we wanted to get a sense of what your thoughts were, and they will talk about what it means for their own practice and the clinics that they run. This is a part of a series of panels that the Office of Clinical and Pro Bono Programs is hosting over the coming weeks to learn both about our clinical offerings at the law school, but also to learn about different forms of legal strategy from our clinicians. This panel is being run as a Zoom webinar, so as the panel goes along, if you have questions, please feel free to populate them in the question and answer function. You can find that function along the bottom of your Zoom. We're not going to be taking questions until the last 15 minutes of the panel, but you are welcome to populate your questions ongoing as they come to you so you don't forget them. I am going to try to aggregate the most common questions as they come in so that we can answer as many of the questions as possible. Just one final note for our audience members. This panel includes both our current Harvard Law School students as well as newly admitted students. So I want to send a special welcome out to our admitted students. We are excited to welcome you to Harvard for now virtually. I imagine particularly for the admitted students, there are a lot of questions about the clinical program more generally, how the clinical program works, all the various options that are available to you. There is going to be a meet and greet offered as part of the admitted students weeks. The Office of Clinical and Pro Bono Programs will be hosting this next week on March 9th. And there's also going to be some pre-work that goes out related to our broader clinical program. So if you have more general questions about the program, we encourage you to attend that session. For now, we're going to focus our time and questions on the particular work of these clinics and the strategic litigation they employ. And so with that, I think we will get started. So I want to start first with introductions from our panelists. I'd love it if all of you could just share a little bit about your biography, your background, your work, as well as the clinics you run. So why don't we start with Deana?
Hi, everyone. Thank you for having me today. I'm really happy to be here. I'm Deana El-Mallawany. I'm a co-lead of the Democracy and Rule of Law Clinic and the accompanying seminar called Legal Tools for Protecting Democracy in America. I'm also an impact director and counsel at Protect Democracy, a nonprofit that has a singular mission, which is to prevent our democracy from declining into a more authoritarian form of government. And we see our mission as increasingly urgent amidst the global rise of authoritarianism. I know many of us have our minds on Russia and Ukraine this week. And here at home, where a growing authoritarian movement is laying the groundwork for future electoral subversion by eliminating some of the obstacles that prevented their attempt to overthrow the results of the 2020 election and interfere with a peaceful transfer of power. At Protect Democracy, we use integrated advocacy. That's a blend of legal, policy, and communications advocacy to bring about change to achieve our mission. And strategic litigation, what we're here to talk about today, is a key component of that toolkit. To give you a sense of the kinds of strategic litigation we bring, I'll just mention a few current examples. We currently represent Capitol Police officers in a suit against Donald Trump under the Klan Act, a Reconstruction era statute that's designed to prevent intimidation of federal officers fulfilling their duties. We're suing for their injuries resulting from the violent insurrection that Trump incited to interfere with the certification of the election on January 6th. We also represent Georgia election workers in defamation lawsuits against One American News Network and Gateway Pundit to recover for the extensive harassment and threats of physical violence they've suffered due to false claims that the defendants have spread that they engaged in ballot fraud in 2020. And then one last example, we represent Lieutenant Colonel Alexander Vindman in a suit against Trump aides and allies, including Rudy Giuliani and Trump Jr. seeking accountability for their concerted effort to intimidate and retaliate against him for testifying against Trump during the first impeachment. So there's some recent examples. I'm happy to go into others as we continue the conversation.
Thanks, Deana. Amir, will you go next?
Yeah, sure. Hi, everyone. Thanks for having me. My name is Amir Ali. I co-direct the law school's criminal justice appellate clinic with one of my tremendous colleagues, Davey Rao. And in my day job, I'm the executive director of a civil rights nonprofit called the MacArthur Justice Center. My own practice for most of my career and at MacArthur is focused on strategic appellate litigation. I'm going to talk a little bit more about what that means. And in this new role, relatively new role for me as executive director, I also steer the mission as it relates to litigation in trial courts across the country. Our issues relate to the criminal legal system, although we've very deliberately defined that in a broad sense. So it is more kind of criminal legal system adjacent issues. In general, that means it spans the criminal legal system from end to end. So, accountability of police officers and prosecutors, the constitutional rights of people who are accused of crimes, to criminal sentencing and the death penalty, to the rights of people once they're incarcerated, and wrongful conviction work as well. I'll end there.
And Phil.
Everybody, thanks so much for being here. My name is Phil Torrey. I direct the Crimmigration Clinic at HLS. So the Crimmigration Clinic is part of the Immigration Refugee Clinical Program. We have two different clinics within that program. There's the Immigration and Refugee Clinic, and then there's the Crimmigration Clinic. The Crimmigration Clinic focuses on the intersection, or really the conflation, of criminal law and immigration law. So similar to what Amir was just talking about, we take a very sort of broad approach to crimmigration work and think about ways to challenge not only the immigration consequences of criminal convictions, but also the implementation of the criminal law enforcement mechanisms like local police and detention centers into the civil immigration space. The clinic is relatively new. It's the only crimmigration clinic in the country. I started it about 8 years ago. And our work sort of spans across several different areas of strategic litigation. So we brought on somebody recently who's done a fantastic job sort of building out our district court litigation, affirmative litigation, class actions and injunctions and things of that nature. My work primarily is in the appellate space. And then we also do litigation sort of on the ground, direct representation, which is an important part of impact litigation as well. So excited to talk to everybody this afternoon.
Thanks to all of you. So this first question, I'll actually start by sharing our word cloud because I think it's relevant. So the term strategic litigation, or as it's sometimes known, is impact litigation. And that can have a lot of different meanings, a lot of different approaches, a lot of different vehicles. So I would love it if each of you could share from your perspective, what do you mean when you talk about strategic litigation with your work? And we'll go in reverse order. So this time, Phil, if you'd start us off.
I was dying to hear what others were going to say first.
You can see the word cloud.
Strategic litigation, impact litigation are terms that we often sort of, to be completely honest with, sort of struggle with internally in thinking about what these different phrases mean. So often you think about impact litigation as being either appellate litigation or sort of large scale district court litigation. And often impact can be made at a litigation level on the ground level with individual representation and really educating courts and informing them of the issues sort of from the ground up. I think that's an important point that's often missed. But the kind of work that we do in the crimmigration space when thinking about strategic litigation is that we really look for sort of cracks within the jurisprudence, areas that we can sort of push the law in a positive direction. It's an exciting time to be kind of litigating in the crimmigration space because there's just a dearth of legal precedent out there on so many issues. And so the strategic litigation that we try to think about is working with local organizations and partnering with community members and community-based organizations on issues that they're seeing on the ground that could benefit from some type of litigation. And I can talk more later about ways to identify that kind of litigation and some potential drawbacks. But those are just some initial thoughts from me on this topic.
Amir?
Yeah, I think that's a good summary. It's really hard to put too much meat on the words because it can describe so many different things, especially when we bring in strategic appellate litigation. And I saw movement lawyering was one of the words that appeared in the word bubble, which is certainly associated with strategic litigation and something that I think about a lot. I'll just kind of break down the two words. I think that's probably the only way to accurately do it, which is when we're talking about litigation, we're talking typically about a case. It could be a new case. It could be supporting a case that exists in some other way as co-counsel because it's a priority for you, or a high stakes case, or as a friend of the court even. And then the kind of more difficult word is strategic. And I interpret that to mean, with a purpose. So there's some end or goal that drives the organization or the lawyer to get involved in the case. And often that, at a minimum, I think that end or goal is the lawyer's or the organization's reason for getting involved in the case or bringing the case. And ideally, and we'll talk about this a little bit more, I think, when we talk about some of the ethical issues, ideally, there's great alignment there, and that strategy, that vision or end or purpose can remain part of the case, so that your strategy carries through. But I think at a minimum, what we're talking about is getting involved in a case with some end in mind based on your particular organization or your particular attorney's mission.
And I'll pick up on that theme of alignment too. I think that's so critical where, for us, Protect Democracy is a mission-driven organization. We are looking to work with clients whose private interests align with our mission interests. And then we have a shared goal of creating change beyond obtaining relief in a particular case, whether it's establishing a principle of law, guaranteeing particular rights, sharpening a legal tool that others can use to vindicate the same rights, or creating clear accountability to deter future wrongdoing. And so really what we're looking to do is work with communities and clients, other organizations that have this alignment of interest, and really with this broader goal. I see in the word cloud, change and systemic, right? We're thinking big picture, broad change rather than particular relief, beyond particular relief.
Can I actually jump in for 1 second? Because I think that's such an important point. And I just want to draw one other distinction, which is that sometimes this type of strategic litigation is just looking for the end that you could achieve in the case itself, right? You could be seeking an injunction that stops a government from doing something, and that affects systemic change. But as Deana just pointed out, sometimes your organizational mission goes well beyond any relief that a court can offer you. And that's where things like movement lawyering and different theories of change come into it. It kind of comes into it not in the definition of strategic litigation, but in the end that you are pursuing, whether it's to uplift some sort of movement or foster propel a movement, or whether it's to achieve something just by virtue of what you can get in court.
Thank you for that. So as you think about these different definitions, there is a choice to engage in strategic litigation as a form of litigation. And so I'm wondering if you all could talk about what are the benefits of strategic litigation, but also what are the drawbacks, and when might strategic litigation not be the right approach? And Deana, could you start us off?
Sure. Yeah, so some of the benefits, like I was mentioning, one goal might be clearly establishing a principle of law. So in our lawsuit on behalf of Capitol police officers relating to the January 6th insurrection, if we succeed, what we're hoping to do is establish that the defense of presidential immunity does not extend to actions by a president seeking re-election to incite a violent insurrection to interfere with the election. And that would be a limitation, an important limitation that has not yet been recognized on what presidential immunity covers. In addition to, and that would be like the main hurdle to our clients obtaining monetary relief in their case. So it is an establishment of a principle of law that would allow them to obtain relief ultimately. It could be sharpening a tool that others can use. So in the defamation case that I mentioned on behalf of election workers in Georgia, if our clients succeed in using defamation as a tool to, defamation law as a tool to prevent attacks, attacks fueled by the big lie that, that Biden was not the rightful winner of the 2020 election, then others can use that tool in the future. There could, deterrence through accountability, as we've learned through history, and Putin is an example of this. When an autocrat's abuse of power is met with impunity rather than accountability, importantly through the courts, then the transgressions continue. And so deterrence is a key form of accountability that can be achieved through the courts. But there are downsides, right? Litigation takes a long time. In 2020, we represented Black Lives Matter protesters and women who participated in the Wall of Moms, who were protecting protesters in Portland, Oregon, from the abuses of DHS officers using indiscriminate excessive force against protesters. And we filed a suit. To obtain relief, through preliminary injunction could have taken a long time, but it was through that suit and by us and many others, and the increasing sort of political pressure and public attention to that event that caused the federal government actually to withdraw forces. And so we helped contribute to a win there, but it wasn't actually through the courts, although there were some limited court victories. So sometimes you have to think more broadly than just in court. Are there ways that you can achieve success outside of court as well? Standing is hard to establish, and there are lots of immunities and defenses that make it hard to obtain relief. And then courts are just not always the most hospitable forum for change. You can lose. So we brought a lawsuit in 2019 challenging the president's invocation of the National Emergencies Act to declare an emergency on the southern border and use Department of Defense resources to build the border wall. That lawsuit ultimately failed, but we were actually able to use the coalition and attention that we had brought to that issue outside of court to make significant progress on legislative change in Congress to amend the National Emergencies Act. And so you think about how the tools relate to one another and how you can achieve change outside of court.
Amir, Phil, anything to add to that?
I think that was very well said. I would just co-sign everything. I know this sort of bleeds into my next question, so I'll pause if Amir has.
Yeah, so let's go to that next question. So all of you have talked about sort of, one of the driving focal points of the work is what is the big goal? What is the mission of the organization? What are we trying to achieve? But I wonder, Phil, if you could talk about what are other underlying considerations as you think about whether you're going to take on a case, and what are the ongoing strategic considerations as the case continues to unfold beyond the big goal, the mission?
Yeah, so I think there's so much to unpack there. I'm going to try to limit myself a little bit and rely on Deana and Amir to jump in and sort of fill in gaps here. But there are so many different aspects of strategic litigation. Specifically, I'm thinking of movement lawyering. I was one of the people that put movement lawyering into the cloud, so I'm glad that Amir picked up on that one. But obviously, thinking about if you're a mission-driven organization, thinking about clients' goals and your goals and when and how those align and how they could differ at any given point in time, and understanding that once you take on a client representation or a client, that individual or those people are sort of driving the goals of the litigation. So thinking about, there's sort of like very specific practical ways in thinking about bringing types of litigation, whether you're bringing a class of clients or individuals versus organizations or some combination of both. So there's these very real jurisdictional issues to think about. But I think a point that Deana brought up that I think is really important and is often missed as well is thinking about the collateral consequences of litigation. So for example, we are involved in sort of a national litigation movement concerning the use of gang database information in immigration proceedings and basically trying to end that. And that litigation has looked different depending on what location you're in around the country. So for example, Chicago has one mode of advocacy that they're pursuing, that because that's sort of what's best and what's being driven by the local community there. Other areas are less interested in pursuing strategic litigation. And part of that is because they're concerned that what you are able to get out of the court is not going to be the complete abolish of the gang database, the total eradication of it. Instead, potentially what you could get is a more secure gang database where there's processes infused into it. And suddenly you have sort of the reverse outcome that you were initially looking for. So thinking about what the potential impact could be both within the court and how to leverage litigation in other advocacy, using other advocacy tools. So we do a lot of work with community organizations who will often use litigation, even just filing a piece of litigation as a potential leverage point for maybe strategic policy advocacy at a state or legislature or at Congress. So those are important aspects to think about. There's also, the forum, you're bringing a piece of litigation in, the timing. These things don't sort of happen in a vacuum. So understanding sort of what the context of the litigation looks like, what's being talked about in the news, what's sort of the national discourse on a particular issue that you're litigating. We often think of courts and judges as being insulated from that, but they're not. And then the last piece that I'll mention in terms of forum and jurisdiction is, sort of one sort of practical point. We often are, I'm sure we're all sort of doing this, but looking in different locations, different fora to bring litigation that we think will have a potentially positive outcome that we can then leverage in other locations. And that's a real strategy that can sometimes work and sometimes doesn't, but it's important to also think about.
Amir, Deana, what would you add?
Go ahead, Deana.
I think that, I think the strategy of sort of like local, sometimes we pursue a strategy of getting local relief and then trying to build on that. And it sounds like there's a similar strategy there.
So, Phil, one of the things you just mentioned is being very attentive to collateral consequences. And actually, impact litigation, strategic litigation can have a lot of critiques relative to different ethical considerations. One of the biggest ones that arises is conflicts. Are there different client interests in part of the group that you are representing that actually are in conflict with one another? Or does the litigation change and evolve over time? And does that suddenly, the big goal, the mission, come in conflict with what some of the initial client interests were? So Amir, I'm wondering if you could talk about these and other ethical considerations that you think about in your litigation work and how you, work around them.
Yeah, sure. I'll touch on it at a high level, and I'll be interested in Phil and Deana's own experiences. But, ethics are an important consideration. They always are as lawyers. And organizations who do this type of strategic litigation have their own vision of change they want to see in the world. And usually also the change they want to see come out of a particular case that they've identified and taken on or initiated from the beginning. But of course, as we've kind of suggested a little bit throughout, lawyering and litigation in particular comes with another organization, or more often an individual or group of individuals who have their own interests, and that's the lawyer's clients. And so, and of course, it goes without saying that lawyers, have an ethical duty to represent the interests of their clients in litigation. For that reason, I think the strategy part of strategic litigation has to necessarily take into account who the client is going to be and what their actual interests are, and evaluate, the risks that they're not going to align. I'll just throw out a couple of strategies that some folks use to proactively address this possibility, and then I'll share my own experience in my practice, which does tend to be heavy on the side of representing individuals. And I take a pretty strict view on this that I think doesn't represent the whole community of strategic litigators. But a couple of strategies folks use to be proactive. One is actually to have your strategic litigation be representing an organization. Ideally an organization that shares the mission you see for the case. And so, for example, my organization has a lawsuit that's been ongoing against the Chicago Police Department for systemic, among other things, systemic use of excessive force against communities of color in Chicago. And in that litigation, we represent individuals, but we also represent organizations who share the same vision we do for the reform we want to see in the Chicago Police Department coming out of the suit. And so, by ensuring, and this is the second piece of advice or theme I often see, is to ensure up front, whether it's an organization or an individual, frankly, that you're clear about what the goals are for the litigation, and try to align as much as possible at the outset on some of the things that could come up and what the goals are of the litigation. Like most things, setting expectations up front is generally the right thing to do and can avoid major problems down the line. I've seen some litigators build this into their engagement letter with clients, the purpose of the litigation tied to the scope of the representation. And I think as both of those two common strategies recognized, the goal overall is to have a situation in which the client is aligned with and very much aware of the overall strategy for the litigation. And I'll just say in my own docket, which is an appellate docket where I'm almost exclusively representing individuals, and they're often individuals who have suffered significant harm in interactions with, for instance, police officers or correctional officers. I take a pretty strict line on this. We can have as much strategy as we would like before we engage a client in trying to figure out which cases to get involved in to set the precedents. And it's often, the strategy we're looking at is what cases are likely to set important precedent that expands civil rights for the particular communities we represent. So we can do as much strategy as we like before we engage the client. But once we engage the client in the area we litigate in, it's the client interests that will always dominate. And to a pretty extreme degree, I'll give an example a little bit later of one instance in which some students came up with an incredible theory for one of our clients that didn't further the initial reason we got into the case, but there was no question in our minds that we would move forward with the idea they had come up with.
Well, Amir, you're bringing us there naturally. Thank you all for sharing so much of your day-to-day work, but let's turn to the work of the clinics and to the extent that your work overlaps with the work that you are asking students to do. Just one quick reminder to all of our attendees, if you have questions along the way, you can populate them in our question and answer function, and we'll be answering those questions in the next 15 minutes. So in the clinical world, can you all just share a little bit, what do you have students working on? How is that work intersecting with all of the work that you just described? And can you give some recent examples? So Amir, I'm going to start with you since you were just talking.
Sure. I just finished talking, so I thought I'd get a little bit of a break, but I guess not. So we structure our clinic very intentionally. It's a criminal justice appellate clinic. So the goal is to involve students in actual appeals and the issues we litigate. And so the way we structure our clinic is to have usually teams of students in pairs, sometimes threes, work on one of our appeals. And we set up the timing such that we're really at the inception of the appeal when students start. They're often kind of surprised by that. It's not a situation where you come in and we've got all the answers. There's no kind of closed book form here where we know exactly where we're going. We have identified the case as one that is sufficiently important in our area for the students to get involved. And we have a theory as to how we get from point A to point B, but the students very quickly learn that they become the master of the record in the case and the case law, pretty quickly in the clinic. 1 week in, I think they're telling us the state of the law, and we're helping them work through the many problems that come up. But the goal is, our clinic, I should say, operates first in the winter term in person in Washington, D.C., and then in the spring semester afterwards. And the goal in that winter term is to go from, you just heard about this case, often in a very complex area of law, to outline, to draft of a brief that is fileable in a federal court of appeals, in a high stakes case that involves the issues I've discussed before. And so it's an intensive, although very balanced time with us in DC, working on a concrete case with the time that allows us to engage in the creative and collaborative brainstorming that we like. And then, of course, allows the time to actually write a brief that can, see some change in the world and also be a nice writing example for the students at the end of the day.
Deana, what about you?
In our clinic, we invite students to become part of the Protect Democracy team for one semester. They're integrated onto project teams where they become sort of full-fledged members, taking a laboring oar in producing the work and not just on strategic litigation, but in the full integrated advocacy approach that we use. So students might be working on, developing a legal theory that will help us to draft a complaint and, oppose a motion to dismiss in a lawsuit. Or they may be working on analyzing policy so that we can make suggestions on policy changes at the federal or state level. They could be developing, part of what we do is getting ideas from off the wall to on the wall. So they might be doing some research and writing to draft a blog post that goes up on Lawfare or other outlets where we kind of seed ideas that we try to pick up on through litigation and through thought leadership. Or they might be participating in a FOIA lawsuit where we're trying to obtain information as sort of a precursor to potential lawsuits in the future. So just to give an example of a litigation example, we did have one student working on the Portland case that I mentioned. He took the primary pen drafting amendments to our complaint and digesting sort of a complex government report that brought to light some additional details that we wanted to include in our complaint, and translating those findings into sort of how we would make a legal argument under the Administrative Procedure Act. And that language was so thorough and persuasive, we included it, wholesale in our complaint and eventually in a draft to opposition to a motion to dismiss. But other students have looked into theories that we have written up in blog posts, for example, that have gone up on Lawfare and co-authored pieces with members of our staff, or just taken a really hard look at some of the legislative initiatives that we're trying to pursue, like the Electoral Count Act and the reforms that we're proposing there, and proposing strategies to do that. So our clinic draws students with diverse interests, litigation as well as outside of litigation.
Phil?
It sounds like we all have like a somewhat sort of similar model. The Crimmigration Clinic, likewise, students really take the lead in all of our projects, whether it's litigation focused or otherwise. So what that means is, like Deana was just saying, and what Amir was saying as well, they take the lead on drafting documents that are going to be filed in court. They're also often the primary point of contact for the client. They lead case strategy sessions. So to give an example, we're gearing up for a big piece of litigation. We're partnering with a law firm. There was probably 20 lawyers on this call, and one of our students led that call, led the strategy session, talked about the different claims that we would be potentially bringing, answered questions about different defenses to that claim that the government may be bringing. Students talk to, we do a lot of work, I shouldn't say with detention centers, but maybe against detention centers. So, but students are the primary contact often as well with opposing counsel. We're usually there as well on those calls, but students argue the cases in court. So they really run the full gambit. And I like to think when I'm talking about sort of clinical education and sort of students' roles, I use this analogy, which may resonate with some and perhaps not with others, but I don't know if anybody's ever been bumper bowling before. I have 2 small kids and we've gone bumper bowling before, where you basically have, you know, an inflatable, or you have like a tube in the gutter so you can't ever get a gutter ball. But the idea is the same in the clinical context. So I like to say that we allow students to make these sort of measured mistakes along the way without ever getting a gutter ball. So we're the lawyers for the clients, the organizations, the individuals. So at no point will we allow a case to sort of get into, veer off into the gutter. But students sort of are allowed to kind of make mistakes as they go, and it's measured and it's steered and it's corrected, and it ultimately all leads toward the end goal of getting that strike, that win. But we are sort of the gutters. We make sure that as the clinicians that everything is sort of moving in the right direction and that nothing is too detrimental.
I like that visual. Amir, you started alluding to this earlier, but I'm wondering if you can share what is the most interesting question or angle that a student has brought to a case you were working on?
Yeah, thanks. I gave some thought to this. It's really hard because we engage our students in mooting my colleagues or myself for oral arguments. They bring all sorts of interesting questions and great questions to prepare us for arguments. But I wanted to tell a quick just case story. It's angle is probably, or even frankly, legal argument is the way to describe this one. But it's representative, and the reason that we love working with students. So I had a case that we had identified and that we were going to appeal to the United States Court of Appeals for the Third Circuit. And I won't get into the details of the issue, but we'd identified this really unjust rule that was leading a lot of poor incarcerated prisoners, people to have their cases dismissed. Really impossible to defend rule, we thought. So we identified this case and we were going to appeal it to the Third Circuit and hopefully set a precedent that really prevented defendants in these cases, correctional officials, from raising this argument that we thought was leading to this unjust outcome. And I had 2 students on the case, both of whom are now off clerking, and I recently got to email them because we not only won the appeal that I'm about to tell you about, but the client recently settled on remand and received a tremendous result. But anyways, coming back to the appeal, we had talked at length for the first 2 weeks of the 3-week winter term clinic about the importance of the case and the theory we had and how to win the issue. And coming towards the final days of the clinic, the 2 students came to me, and I think they were a little bit unsure how to deliver the news, but their news was that they had found this third argument that we hadn't considered that was specific to our client. It was under a doctrine called law of the case. It's a rule under the law that basically says, if a court in your case has previously ruled on an issue in your favor, that kind of governs going forward in your case. Happened to be a legal issue that, mission-wise, strategy-wise, my organization, the reason we got into the case, we couldn't have cared less about it, to be frank, about setting a precedent on law of the case in this way, and hadn't even known that argument was kind of latent in this case. And I think the students were worried about that. They were saying, if we win this, they wouldn't actually solve the problem we wanted. And for us, again, it was a no-brainer. Of course, this was a legal argument we could make for our client that would prevail in the appeal and revive his suit that had been dismissed. So we made the argument. The students researched it very quickly, threw it in the brief. And it wasn't the strongest of the 3 arguments, actually. And this is you can see how strategic litigation can get interesting here with what I'm about to say, because the Attorney General's office on the other side read our brief. And what they did in response was they actually conceded error on that third argument the students had raised. And here I think the students were again stressed. They said, oh no, we're going to win now on the issue that we never even cared about. And, when we talked about it, we all came to the view, which was that this is incredible, right? We have now won this case for our client. And what we ended up doing actually was walking into court. We wrote a reply brief and I argued this case. And the position we took was our client has won this appeal. But what you should know is that the Attorney General's office is really afraid of you resolving the broader issue in the case that is leading to all sorts of injustice in your lower courts. And you should just go ahead. You have the choice to do it on the conceded error, the conceded basis, and just send this back down for our client, or to resolve the broader issue and do something that's good and right in this case. There's nothing that stops you from doing either. And the court actually took the invitation to issue a published opinion on the broader issue and send it back. And in that way, our students had based all but guaranteed victory for our client. And fortunately, in this instance, we were actually able to still carry out our mission. We would have been very happy to report to our client that that he would win without that extra cherry on top. But I thought it was a good example. Not every case has a latent issue that students are able to identify, but students do bring that sort of energy and clear-eyed, fresh-eyed view to our cases.
That really is an incredible example. Thank you for sharing that. Deana, I'm wondering if you can talk about, we've been now delving really into the clinical work and doing the hands-on experiential learning, but every clinic does have this classroom component. And so can you talk about how you think about the interplay between the classroom component, the clinical work, and what integration there is?
Sure. Yeah, so in the seminar, we kind of examine and really test the theory of the case on how to protect American democracy. And that means really taking a closer look at the legal and theoretical underpinnings of both the problems, the authoritarian threats, and the solutions. That's, the tools within American legal doctrine and the political system for addressing the threats. And really kind of grapple with those both in a theoretical way and in a practical way. So students can learn how to spot issues in the democracy landscape and develop their own theories of change for how to address those issues. The way that they're integrated is that, as we encounter themes or threats within our democracy in the seminar, for example, the spread of disinformation or the big lie, students who are engaged in that, in work related to that, will have an opportunity to present their clinical work to the class and become sort of the subject matter experts for that session. Students also have an opportunity to present their own project proposals as though they were members of the Protect Democracy staff that identify a problem in our democracy, and then a theory of change for how to address it. And that really starts to exercise the muscle of how to use the tools that we've been talking about throughout the semester.
Thanks, Deana. And Phil, can you talk a little bit about your pedagogical goals for the clinic? What skills do you hope students are going to emerge with, and what you're really driving towards?
Yeah, absolutely. I can highlight two things specifically that I think are particularly important to me and my pedagogical goals and what we try to emulate in the clinic. The first is legal research and writing skills. I'm sure this sort of emulates across most clinics, particularly in this particular kind of strategic litigation space. But legal research and writing is a skill that has to be sort of honed and used over and over again. And we have different methods that we use in this clinic in particular that I am hopeful will sort of help advance students' ability to take their legal writing, legal research skills into other areas of law, even if it's totally unrelated to crimmigration specifically. And the other thing that I think is particularly important in a strategic litigation space, and really any kind of clinical space in which you're operating, is teaching students how to be creative with the law. I think in particular, your first year of law school, you're learning about sort of the foundational principles and tools and rules that are related to law. You're reading about precedent, you're learning how to apply precedent and to leverage precedent on behalf of a client. But so many of the spaces that we all operate in, specifically when you're looking at movement lawyering and strategic advocacy, that precedent just doesn't exist. So I don't know how many times we've sort of taken a case and we'll take a first crack at thinking through the strategy, and we'll come to our first case team meeting and students will be like, I just don't think we can do this. There's no case out there that says we can do this. And my response is, if there was, we wouldn't be doing it. Like we have to think creatively about how to use different types of cases and tools and precedent, and how to leverage that for our particular mission on behalf of a particular client. And I think that's such an incredibly important tool that clinics in particular can provide to students in law school.
Thank you, Phil, and thanks to all of you. So this is the end of the formal question and answer, but I would encourage all of our attendees to put in questions and answers in the actual question and answer panel. Or if you'd like to answer your question live, you can raise your hand and we can take you off mute to ask a question live for our panelists. So one question has come in, and curious your all take. There's a question in terms of what is the background that you need to go into strategic litigation? A lot of you have worked at big law firms, and the question is sort of what is the necessary background? Do you have to go to a big law firm to get that type of practice? Where do you get the skill sets necessary to do this work? To any of you?
I'm happy to take like initial step. Oh no, go ahead. Go ahead.
No, go for it, Phil.
I knew I was gonna cut somebody off as soon as I jumped in. Go ahead, Deana, you take it.
I was going to say no, absolutely not. You don't have to go into big law to do impact litigation. There are just as many, if not more, attorneys who have come through public interest careers entirely and have specialized in this kind of litigation. Either through direct representation of clients or representing organizations on behalf of a mission-driven organization.
Is there something you all would emphasize in terms of the experience that they should get to do this work?
I think taking a clinic at HLS probably is the best experience you could get. One
of these three clinics in particular.
One of these three in particular, exactly. Maybe the conflation of all three. I would like 1000% agree with what Deana was saying in terms of not needing to go to a large law firm in order to pursue this kind of work as a career. And I'm half joking really when I suggest, the kinds of skills that you would gain from being in a clinic, I think is particularly important. And I'll just highlight the piece that I mentioned about making mistakes. When you're learning how to do this kind of stuff, to be in an environment where you have trained lawyers who are responsible for the case and are supervising you on the case and ensuring that things aren't going to go off the rails, it's such a unique opportunity to be sort of at the forefront of that strategy and that litigation, to have that kind of safety net there. And so that's why the kinds of skills that you would gather in really any of the clinics, I think would be important for pursuing this long term.
Another question that came in that's a variation on the theme, which is almost the alternative. Actually, is it difficult to break into the field if you've started in a big law firm? And are many of these strategic litigation organizations looking for folks who have been working in public interest their entire careers?
I'll try, since I didn't pipe up last time. And I'm glad this question was asked. I think it's a good kind of flip side of the first question. And if the three of us all have big law experience, I think that could be misleading in terms of the kind of entry ticket to doing this work. And I very much co-sign with what Deana and Phil said. This is kind of how I would look at it, is this question, is there a risk of going into big law and not making out to do this work if this is your real passion? And I think the answer is yes, actually. I mean, I went into big law for financial reasons and happened to have a very good time there. But there are a lot of folks who go in, will surprise you to know, wanting to do this type of work who then don't. And that could be for very good reasons, or it could be, despite their desires. So I always advise students that if you know what you want to do, don't try to take detours to get there just because you've seen other people take that detour, or at a minimum, come to a panel like this and really ask the hard questions about whether it's necessary. And I'd actually, I don't know that I'd say it's good practice for that reason to go to big law to do this work. I will say that for those of you who are feeling pressure to go to big law, whatever that reason might be, but financial obligations, for instance, that all is not lost. And I actually did find, it was difficult, I'll say, but I did find that in big law, I was able to set myself up to do this work because of the resources that the firm had and the possibility at my firm and a number of other firms offer this to do pro bono in a way that was not so different from the strategic litigation. So my pro bono docket at the law firm really looked like the strategic litigation docket I have today. And it was because the firm had the resources and allowed me to do this pro bono work that I could make that transition. And so I would just say, if you are feeling compelled to take that detour, I wouldn't recommend it, but if you're feeling compelled to, then don't lose sight of the end goal you have, and think very deliberately about what type of firm would allow you the freedom to kind of shape your docket in that way, and get the experience you might need to have to go work at do the work Phil does or Deana does or that I do.
This next question I think is so interesting, and it's really about your own mental and emotional resilience. This work is hard. You're taking on hard issues that are affecting real people in challenging, unjust ways. How do you keep up your stamina, your resilience, your spirits, another way to put it, to continue to take on this work day after day?
I'll get us started. This question really spoke to me. Engaging in this work, it is hard, but it also gives me personally a boost because I feel a sense of agency. I know I can wake up every morning and get to work on this problem that I feel like is very pressing for our country, and that gives me, even when we lose and it's hard, it gives me a sense of there are things within my agency that I can try to bring about change.
Yeah, no, I would totally agree with that as well. And I feel very similarly. Can think back to, under the prior administration when, immigrants' rights were under such an onslaught, just a constant deluge of horribleness coming down from the executive branch in particular, and friends reaching out and being like, what can I do to help? What can I do to help? And I felt so privileged that I was in a position to leverage the privileges that I have being here to help in that space. So that actually, in a kind of odd way, was uplifting for my spirits in particular.
So Phil, you mentioned this a little as just one of the many considerations, to think about with strategic litigation. But one of the questions is focused on how do you deal with the potential risk of setting negative precedent, that the precedent you want to set could, end up in the reverse. How do you think about in the initial consideration and ongoing when you're doing this work? And answer to anyone, I just referenced, Phil, that you talked about this a bit earlier.
I'll just say it's a great question, something that I think about a lot, especially since we do appellate litigation, and some of it does go to the Supreme Court, where our issues and our clients don't tend to fare all that well. And the answer is that we try to be as cautious, and that's part of this. I guess the real answer is that's built into the strategy, so that can be handled in many ways. One of the most concrete ways it manifests for my group is that we do a lot of defensive strategic litigation. We do a lot of litigation to keep cases out of the Supreme Court. And that is part of our strategic litigation docket, is getting involved when there is something that we see as a significant risk of going to the Supreme Court.
This is an interesting question that has come in. So you all spoke a lot about in the clinics various skill sets that students are developing: legal research, legal writing, advocacy. How do you think about developing judgment? Because that is in many ways the thing that lawyers are most valued at. It's not necessarily being able to look up a case, although that's important. It's being able to make both the substantive legal judgment and the ethical judgment that is necessary for the case. How do you develop that? With bumpers.
I'll just say, I think Phil mentioned earlier, like the opportunity to make mistakes. And I think working in an environment where you have close mentorship and supervision early on in your career and can get that experience, because the way you can make these strategic judgments is by seeing a case play out from beginning to end and really understanding what's likely to happen in the course of litigation. And so having an environment that allows you to, in a safe, because there's supervision and good mentorship, make those sorts of decisions and have them caught ideally, or at least be supported in the event you make a mistake is important. I'll just say one other thing, which is that the fact that the student is asking this question is a very, very good sign, and you're probably off to a very good start in terms of having and really thinking about that judgment piece of it.
We're coming to the end of time, so I would ask that each of you answer just one more quick question, which is, you have a lot of folks who took their afternoon to spend with you and learn about strategic litigation, which indicates some level of interest. What advice would you give to these students as they think about this potential career choice or method of learning for themselves? Phil, let's start with you.
What I would say, so I have like two pieces of advice just really quickly. One would be to not be so concerned about pursuing a particular doctrinal area of law coming into law school. I think it's such a unique opportunity once you're in law school, and there's a lot of pressure to narrow and to land on what it is you want to do substantively coming out of law school. But try to gather as many skills as you can, take these amazing clinics, take different professors' courses that you find interesting and that are great and that are going to be mentors. And that's the second piece. I think law school is an important place to really be gathering mentors that are going to be sort of in your corner professionally going forward, not only people that are going to help you set up your career, but also to bounce ideas off of as well.
Amir?
Phil's still part of mine, but I'll say it slightly differently on this idea of not being too focused on the doctrinal area. And I think that the question I get a lot from students is what is the most important thing I could be doing? I know I want to do impact work or strategic litigation. What's the most important thing I can spend my time doing? And that's a good question, as long as what you mean is you want my opinion, but only you can really decide what's most important to you, obviously. But I think it's also kind of an incomplete question, because and somewhat of an unproductive question that you have to be careful of, because one thing you really should take into account is not only kind of what's the area of law, whether it be environment, housing, there's so many really important areas of work being done, but also what it looks like to practice in that area of law, because they actually do look different. They're not just fungible topics. Litigating a voting rights case looks very different than the type of litigation I do. And so taking the time to get that experience and understand what it looks like to actually litigate in that area of law, and whether you derive fulfillment from the mechanics of litigating it, is really important, because that's what's going to make the difference between whether you're a great lawyer in that area or not, is whether you really enjoy the practice day to day. And the other thing, the reason I say it's a little bit unproductive, is that you can paralyze yourself by that question. If you're constantly asking, what is the most important thing I could be doing with my time? It's really hard to focus on the probably very important thing that's on your desk at that moment. And so it can be a recipe, going back to that question about staying happy, can be a recipe for unhappiness in this sort of field if you're constantly second guessing whether what you're doing is important enough.
Deana, you have the last word.
Thank you. Two pieces of advice. First, become students of social change. What has worked in the past? How have movements achieved change over time? It'll help to understand how change works, and also to think through potential blind spots that you may be developing over time, and really be able to see potential unintended consequences, in particular to marginalized or vulnerable communities. And then second, don't forget your people skills. I think that, in law school, we can be so focused on the academics that a huge part of this kind of lawyering is developing coalitions and relationships with other organizations, and then being able to talk to clients who are in difficult positions, who are really suffering, and be able to connect with them on a human level and inspire confidence in you and the shared goals that you will be pursuing together. And so just remember that, that being a lawyer is also being a human being, and it's an important part of our growth as attorneys.
Thank you for that, Deana, and thanks to all of you. Thanks for joining us today. It has been illuminating for me. I always learn something new, and I hope all of you learned both about the strategic litigation work that these three incredible panelists are doing, as well as what is happening at Harvard Law School. Have a wonderful afternoon, and see you all soon.
Thanks, everyone.
Everybody, take care.